It's hard not to notice the pattern that has emerged in copyright cases in front of the Supreme Court. There haven't been all that many of them, but we've seen two important players on the bench for a couple of decades. Ginsburg tends to find in favor of intellectual property owners and authors, and Justice Breyer tends to favor technology and what I'm calling repurpose or redistributors. Somebody who wants to use the intellectual property basically over the objections of the creator or owner of the intellectual property. We've got a big case this year called Aereo, ABC v. Aereo, about a new technology for redistributing content collected from the airwave broadcasts of network television. So one of the things to look for in the Aereo decision is where are Ginsburg and Breyer going to land on the issues. We've seen this play out over a course of a number of cases. New York Times v. Ticini. You see Ginsburg write in favor of the intellectual property owner, the author who created the work that was at issue, and you see Breyer joining Stevens' dissent, suggesting that the New York Times, who in this case is the redistributor of the content, has really already paid their license and they deserve to be able to use the content. In Eldred v. Ashcroft in 2003, Ginsburg wrote the opinion finding that it was acceptable to extend the term of copyright from 50 to 70 years beyond the life of the author. And Breyer falls on the other side, writing the dissent that says, no, it's too long. It's supposed to be a limited time. Works are supposed to enter the public domain so people can use them and repurpose them and redistribute them. In MGM v. Grokster, a 2005 case about peer-to-peer downloading, it was a 9-0 decision, but there were two concurrences, one written by Ginsburg, one written by Breyer. Even if there was not inducement, Ginsburg found in favor of the intellectual property companies who wanted Grokster shut down. Breyer writes a concurrence that says, all right, if there hadn't been inducement, the service is actually okay because it supports the redistribution of content, some of which is not copyrightable. In Golan v. Holder in 2012, the Ginsburg opinion pulled some works out of the public domain. Ginsburg, again, favoring the intellectual property owners by returning their rights from the public domain, and Breyer dissenting, saying, nope, the repurposers, the redistributors, the people who want to use these works that had been in the public domain, trying to find in their favor. In Kirtzang in 2013, Breyer found in favor of the redistributors over the objections of the intellectual property owners because their rights have already been exhausted by the first sale. And Ginsburg found the opposite. Ginsburg's dissent suggests that there should be rights in the intellectual property holders to prevent the importation of these books. Ginsburg's dissent favoring intellectual property owners, and Breyer's opinion favoring those who would redistribute intellectual property works. Even this year in Petrella v. MGM, Ginsburg's majority opinion says, yes, the intellectual property owner has the right to bring cases when an offense happens within the 3-year statutory limitation. Whereas Breyer finds in favor of the repurposer redistributor, MGM, saying they should have brought this claim a long time ago. So you see Ginsburg favoring the intellectual property owner, the screenplay owner, and you see Breyer favoring the intellectual property redistributor and repurposer, MGM. When we look at the Aereo decision, which should be coming out in a few weeks, what you would expect to see is Ginsburg favoring the intellectual property owners, the networks, and you would expect to see Breyer favoring the technology that serves as a repurposer redistributor. Will this schism reappear? And if it does, who will be more effective in rallying a majority to their side? If history is any kind of guide, Aereo better have a backup plan because it's been Ginsburg.